think, Joe, you're going to kick it off, and then I've got some initial comments as well. So,
Joe Zender with the Bureau of Planning and Sustainability. So today is our last scheduled work session on the draft comprehensive plan, and there are three topics that we'd like to cover. Anti-displacement policies, including the language about community benefit agreements, historic resources, and employment land mapping. Different staff will join you for each of those issues. We're starting off with Eric Enstrom and Betsy Ames for the anti-displacement and community benefit agreements. So we'll cycle up as we go through the session. And remember, we've picked these topics to provide an opportunity to go into some greater depth. We've also selected these topics to, based on really the volume of testimony we've gotten. So these are issues that have been of particular interest to the community and to the public. At the end, Eric's going to go over the next steps. We have hearings scheduled on April 14th and April 20th for proposed amendments, and we'll talk about that process, I believe. One introduction, I wanted to introduce Brandon Spencer Hartle in the first row. He's going to join you today at the panel. He's our new Historic Resources Program lead. So with that, I'll turn it over.
Want to emphasize a couple of things, I guess, as we go into this. One, on the community benefit agreement work, I want to appreciate the work that a number of bureaus beyond the Bureau of Planning and Sustainability have been doing. So that's why Betsy's here, but not just OMF, but also other infrastructure bureaus have been working on this. It's important that we try to get to the level of policy rigor that the council and the community want to see here, but we also have to make sure it's actually implementable and that we are using the plan and the code in the way that the plan and the code can be used. I guess that would be my characterization of the boundary between doable and not doable on this issue. On the historic resources policy, just a couple comments there. Looking forward to the discussion and it's great to have Brandon on board. This is an area in which I've been looking at some additional amendments, and I think that another area where, again, we should try to maybe improve on. I had a good discussion yesterday with the Planning and Sustainability Commission, as you know, the usual 85% rule, that they did a great job of bringing us a good draft plan. I think historic preservation is another area where both members of the council and the community want to up our game and maybe do more than was originally proposed in the plan as it was brought to us from the commission. So with that, I'll turn it over to Eric and Betsy to take us off into the subject of community benefits agreements.
Thank you. And we introduced this topic a little bit in your initial series of work sessions last fall before we had public hearings, but I wanted to start off by just reminding you that there are a number of policies that the Planning Commission, Planning and Sustainability Commission recommended in the plan in the broad category of anti-displacement and addressing gentrification and housing affordability and things like that. There's a summary. The second document in your packet is something we provided last fall, but it's a summary of some of the key policies that are in the recommended draft that relate to this topic. And we're not going to talk about every one of these policies today, but I just wanted to make sure you had that again to frame the larger question. You also should have some advice from the city attorney on a variety of policies, including a few of these. So we recommend that you look at some of that material. Betsy's here because you heard a lot of testimony from the public about these policies. Many of the folks who testified urged you to retain this emphasis on anti-displacement and community benefits. There was a robust discussion at the Planning Commission about this as well, in the details, but also as a broad principle. What we want to focus on today is looking in particular at some of the community benefit language, and we have, since the public hearings, we have followed up with a multi-bureau effort to meet with some of the stakeholders again, meet with the different infrastructure bureaus. I think the planning and development directors discussed this, and working through some of the implementation detailed questions that the bureaus have in terms of how this would work, and then some of the legal questions as well. The document that is focused on community benefits is the next document in, which is entitled Community Benefits Policies. And it has a couple general framing questions without getting into the wordsmithing quite yet. We are developing language, but it's not in this document. And I think I want to turn it over to Betsy then to walk through this memo and the questions.
Hi, Betsy Ames with the Office of Management and Finance. As you may recall, back last year, my boss, Fred Miller, sent a memo to council with some comments about various elements of the comprehensive plan. And one of the items that he highlighted is that there are a couple of references to community benefit agreements in the comprehensive plan, and he had some concerns, and in discussing with other infrastructure bureaus, they had some concerns about including a particular tool in the by name in the comprehensive plan, because our discussions with various people led us to believe that there may not be common understanding of what exactly that tool is. At that time, he said that he didn't want to make any specific suggestions because we wanted to understand better what the community's interests were, and then be able to, subsequent to those discussions, make some recommendations on specific language. So we have been working with the Bureau of Planning and Sustainability to convene some meetings with the Anti-Displacement Coalition, and have had a couple of meetings and many communications back and forth. And I would characterize those meetings as very productive. We've involved the Bureau of Parks and Recreation, the Water Bureau, the Bureau of Environmental Services, the Bureau of Transportation, as well as some of the central services bureaus, procurement services, and facilities have been involved, and have had a couple of meetings with the Anti-Displacement Coalition, and would like to thank Pam Fawn and others from that organization for having these dialogues to really understand what the community's interests were, and to share that we have common values. I think many of the things that they're talking about that they think can be achieved with community benefit agreements are things like minority women and emerging small businesses participation in city contracting, but also community engagement and involvement in shaping what our programs and projects are. Long-term affordability and mitigating for displacement, looking at small businesses that may be affected by our projects. So a lot of things that go well beyond the construction contracting world, which is what our community benefit agreements, as we've defined them in the city, apply to. In terms of kind of the goals and outcomes, I think city staff and the community are largely striving for those same outcomes, and it's very consistent with what the council has talked about, not just in this context, but in others, in terms of sustainability, equity, anti-discrimination, anti-displacement, et cetera. So we have had those conversations. We've drafted some language that we've been sharing back and forth. We don't have a consensus on those at this point, waiting for some council direction at this work session, but we have a series of questions for you. The document before you, the first page is kind of the overview of the questions that we want to get that high-level direction from you. The third and fourth pages have some discussion that gets into a little bit more detail about what different folks are talking about when they talk about community benefits, with some specific recommendations from city staff, from the various bureaus within the city. And then the fifth and sixth pages are the relevant sections of the comprehensive plan. Our recommendation from city staff is to only amend item policy 3.3C and policy 8.32, but we thought it was important to see the context that there are other policies that touch on related aspects for you to consider as you look at these. The last thing that
What we see on page 5 is is that your recommended language?
No,
That's
page 5 and 6 are the existing sections from
From
the
the PSC.
current PSC
Right.
recommended draft of the
Okay.
comprehensive plan.
Okay.
We would prepare recommended language after we get some direction on some of the questions on the first page.
So I don't know how you want to,
So as Betsy mentioned, there's two policies that are the focus of this discussion that refer to community benefits, 3.3C and 8.32. 3.3 is in the broad Chapter 3, which is about overall city structure and urban design. So it applies to many things beyond public facilities. It applies to how we want to grow as a city. It's a broader chapter. Chapter 8 is the public facilities chapter, and those policies are specific to how we develop our public facilities. So there's a different focus, but you'll see some parallel concepts in each of those policies. And we want the language to reflect the different purposes of those policies. The policy in 3.3 is more likely to be used in the context of private development. The policy in 8.32 is more likely to be a relevant factor in public infrastructure that we're financing or building. The first question that is raised in the memo is, should we be so specific with the language in policy 3.3 to mention community benefit agreements, or would the council prefer to be broader rather than mentioning one specific term? And has been staff's recommendation that you, within the bureaus, that you consider that broader term rather than being so specific, again, because there are different interpretations of that tool, and they may evolve over time, and there may be other tools that are able to accomplish those goals. The second question is kind of around the scope of the policy. Should the policy address not only when we're providing direct assistance, as in monetary contributions to a development project, but also when we assist through indirect assistance like tax abatements, or if they're folks are indirect, essentially financial benefit. And the third question is, how do we address this? Should we be looking at this policy and frame it so that it applies to when we, through our action, create additional entitlement? Should this policy govern our interest in getting community benefit from those, capturing community benefit from those additional entitlements that a property owner may get through a zone change or a plan that we may do, or an infrastructure investment?
So let me ask a practical question, because my guess is that the Housing Bureau and the Parks Bureau would be the most impacted by this language. Parks has 125 different partners, nonprofit partners that help manage the system. So, and the Housing Bureau almost exclusively contracts with mission-driven nonprofits to deliver affordable housing. So when we say in 3.3C, where I think you could easily argue that whether it's a tax abatement, federal funds, general fund, or some other transfer of public dollars, you may be triggering this. What are we encouraging our nonprofit partners to do under this language?
from a housing perspective, what the current language would say is that we should be requiring or encouraging a community benefit agreement as part of our providing funding for an affordable housing project, potentially. That's what it could be saying, or it could be the expectation could be set that that's what this language would require. I think one of the things that we talked about when we've talked with PDC and others is that we have certain baseline requirements that we have regardless of whether it's a CBA or not. The Housing Bureau, when they're giving out money, there are certain sustainability standards that we have to meet. There are certain contracting standards that we ask our providers to meet. So if we want to have the language be broad enough to say some of these things are just going to be requirements, some of these things are going to be negotiated on a one-on-one basis, some of these might be aspirational goals, we would have broader language than just community benefit agreements in the comp plan.
So Betsy, I guess from my point of view, there's just two issues here. One, there's the question that you're asking us to think about in terms of what should or should not be in a comprehensive plan, and then how do we describe our values in a comprehensive plan? And what I understand the legal team is concerned about is if you cross a line, you're arguably turning certain kinds of policy and legislative issues into potentially land use issues. And we have to be at least aware that they're at that line. But the second thing we may be doing is setting community expectations. And I guess since I've been at the helm of both parks and housing, I think we probably need to be a little clearer about what the implication of this language is. The language, we're kind of going in two different directions here. We're saying in the comp plan, let's have the language be broader and more aspirational. But it's still going to have impact on how we do business, particularly with our nonprofit partners. And at some point, I'd like to get a clearer sense of what kinds of changes in behavior we're going to be requesting, because this is going to inform RFPs. It's going to have potentially a cost impact. There's a capacity question. I'd just like to know what it is that we are contemplating shifting to our nonprofit partners, and I'd also like to know what is likely to happen on a positive. What's the likely outcome of this? Because we don't want this just to be aspirational and then come back in 5 years and find that it's still aspirational. So what does, and I say this with all due respect, I'm not sure I still understand what the impact is. So I would need to have a clearer sense of specifically what are we proposing to require of our nonprofit partners.
I want to just remind the council that the impact goes beyond just the nonprofit partners, the other bureaus involved, potentially transportation. The policy implies potentially a process or a negotiation with the community over a large transportation project that could result in a community benefit agreement involving for-profit developers who benefit from that transit investment or that street investment. And so it's broader than the potential impact, depending on where you set this, is broader than just our work with nonprofit housing developers. And that's in the private development world, the question is it efficient for us to negotiate agreements with developers who benefit from specific investments, or is there a broader way to capture value when we're making investments in the community, like the discussion about the Nexus study with the Housing Bureau and broader system development fees or charges that get at that, or as opposed to a negotiated deal with each investment?
So let me, just like you, Commissioner Fish, I think I understand this set of questions, but let me play back where I think we are and what guidance I think you need from the council and see if I've gotten it right. It's okay if I haven't, but it will at least help to get it out where I think we are. So people in the community advocated for, and the PSC agreed with, a broad set of policy planks in the plan about anti-displacement. One of those was very specific about community benefits agreements. There's a debate underway within our city staff, but the opinion that we're looking at here is that both because it might be too narrow, it might be too dated at some point, and it might involve legal entanglements. Specific mention of community benefits agreements is maybe, in that opinion, not the way to go. And we want to stay true to the spirit of the planks in the plan about anti-displacement and about using tools like community benefit agreements. The question, if I've gotten that right so far, the question is, so how might we do that in other language? I realize you haven't drafted it yet, but I bet you've talked about it. So if you want a nod from the council, either a shake of the head, nope, stick with community benefits agreements, be specific about that in the plan, that's as good as it gets, or, well, we think you could still improve on that. What do we talk about in the plan if we take that road?
I think that's one of the directions we're looking at, and as Betsy mentioned, we're in discussion about specific language that accomplishes that, but we wanted to have this moment with you to confirm if that's the right direction.
So if I can just interject here, we've received guidance from our attorneys about several provisions in the comp plan that raise the risk of legal entanglements or, legal entanglements. And so I guess, I think it's incumbent on us at this stage in the process to be very cognizant of that. And so I guess I feel like I'm being asked to wordsmith something where I'm not even sure it should be in the comp plan because of the legal entanglement issue. So where do we have that broad discussion, or where does that get interjected here, other than memos we've received from city attorneys?
Someone who's very good at avoiding legal entanglements just came to the table, but let's let.
I just had a brief suggestion. Susan Anderson, Director of the Bureau of Planning and Sustainability, and that is the community benefit agreement can be broken up into specific pieces, related to minority women and emerging businesses, related to sustainability issues, related to housing affordability, or, all of the different issues. And I think something that might be really helpful to us in crafting this language would be sort of a two-step vote. One, or a nod of the head, one, do you want us to pursue breaking into pieces? And if so, then we can do that and break it into the pieces with specific bullets. And then you can look at those and say, okay, this one, and this one makes sense to me as part of the comprehensive plan. This one and this one are important goals, and we want to do those, and we want to do those some other place, something like that. And so I think the first step.
But yeah, we need
would-
some guidance, I think, attorneys too, about
Exactly,
the legal entanglement
right.
risk. I mean, I can look at language and say, that looks good, right? But I want to hear from our attorneys too.
Right.
Sorry.
They've suggested ways to do that, Commissioner, and I think as long as we go with the values and the principles, then it's actually going to work out better because we're trying to set policy for the next 20 years. In my discussions with people in the community, there are a dozen. Everybody you talk to has a different concept of what is meant by a community benefits agreement. There's project labor agreements, which have some meaning as well. And I think if we go to the values, as Susan just suggested, in terms of, who are we trying to help, or what are those values and principles, that would be the way to go in the comprehensive plan. The other piece that I wanted to just insert here is thinking about long-term community benefits. So we're not just talking about the projects themselves, but who works in them, ongoing, who has the ongoing benefits. And then lastly, not every public project needs to have a specific community benefit. In some cases, the project itself is the benefit. If we're repainting a door in a community center, we would not expect to have an additional component of community benefit other than the door now looks much nicer than it did before.
Just add one thing. I completely agree with Commissioner Fritz that we should move to a more values-based proposition in the comp plan. I agree with Dan that we've been given legal advice about entanglement, and I don't want to play the lawyer on that one. I mean, we've been given specific advice and examples. I think unless you have a disagreement with that legal advice, I think we should follow it. And the third thing is, I do think we have potentially a language problem. You say community benefits agreement, I say community benefits agreement. We could actually be talking about entirely different things. And because the council has embraced a, quote, community benefits agreement, or in its alternate form, a community benefits plan approach to doing projects, I would be loath to incorporate that language in here because I think you're going to have confusion between what we've already adopted by resolution and what the community is talking about more generically. So I like moving away from community benefits agreement because it avoids the confusion with what we've already tackled.
That's essentially what we're trying to get at with this discussion. And then the part two of our question, or the other bullets there, sort of get at the depth, which I think you just touched on, Commissioner Fritz, with the door example. That how deep do we go with applying this policy? Is it when there's major public investment? Especially, how far do we go in applying the policy to private development or other partners? Is it major? Is it smaller? Is it negotiated every time? Or is there a general understanding of the benefits we're trying to achieve across the board, but it's not necessarily negotiated with each project?
And I think the policy and the comp plan needs to be broad so that future councils can decide what is our threshold at this point for various things. Not everything that we would have in the implementation needs to be in the comp plan. In fact, most of it should not be.
I think that's, I'd like to move to the second policy 8.32 and just pose those questions. So again, this policy is in parallel to the earlier policy, but it is more specifically aimed at public infrastructure and public facilities. So again, a repeat of the same broad question about whether we use the specific language. Then because this gets overlapping with construction contracts, I think the second bullet gets at the question of how do we handle that. Many people's definition of benefits goes beyond the construction contracting phase into later phases of work or earlier phases. And so how does the policy address that? And then how much, an aspect of the community benefit agreement is the engagement part, or the public involvement aspect, which is the part about negotiating with the local community to arrive at what the benefit is desired, and how much of that language needs to be repeated in Chapter 8 in that policy, or is it sufficient that we've got a public involvement chapter that applies to the whole plan?
I'll take a shot at that. My opinion at this point is, the answer to your last question is no, that we need to try to adopt language that embraces tools like the community benefits agreement, but doesn't simply rely on the public involvement portions of the plan. You seem to believe, again, I'm putting words in your mouth, that such a thing might be possible in terms of drafting language, if that's the sense that you get from the council. So I think Commissioner Fritz stated it well earlier, that we try to really honor the spirit of what came in to us, but we're not trying to so much fuzz it up as widen it in its construction and avoid this problem of making things vulnerable to legal appeals that shouldn't be.
My recommendation at this time would be for us to go back and draft a broader policy for both of them. Break it into bullets so you can easily see which ones you agree with, and then ask the bigger question to the city attorney and make sure that they are agreeing with the language that we've come up with. And if they don't agree, or if they have reservations, to outline what those reservations are for you.
So, yeah, and just to come back to the point I raised earlier, I mean, in this attorney memo we received November of 15, there's a statement that these policies create some risk that non-land use housing bureau activities could be challenged as land use decisions or create unrealistic expectations of what the city can do. And I certainly don't want to be setting up housing bureau activities to be challenged as land use decisions. I mean, that's a no-win situation.
I think that's a sentiment shared by all of the bureaus that are either investing in community partners or in specific infrastructures of the city. So we would work closely with the city attorney on any language to make sure that they're comfortable with it.
Mayor, I think this conversation's been very helpful, because my takeaway is we're embracing a set of values. We're distinguishing between what can and can't be in a comp plan, and we're asking for some clear legal guidance. And I think that's the path forward, and gets us out of the wordsmithing prematurely.
So it sounds like you've got a pretty broad agreement here on that approach. Anything else from us on this issue?
One other item that the bureaus have talked about. The bureaus are very committed to following through with the comprehensive plan and making sure that we're implementing it over the next years in both our own projects and others. One of the questions that comes up from bureaus is, what does it mean to be a significant project, and when do we have to do an impact assessment? Many of the requirements that are both in the anti-displacement policy and others, as implementers, not necessarily the planners in the bureaus, but people actually managing projects, they have some questions. And one of the ideas that has come up is developing some kind of implementation guide or manual to help bureaus in the future, so that they know, you know, if it's an underground pipe, which has very limited impacts just to one street, what are the types of mitigations or analysis that needs to be done compared to a major investment in a new streetcar system or bus rapid transit? You know, what are the different scales? What are the different types of projects? In talking with the community, they recognize that one size doesn't fit all, and there's some things where the investment by the city is the benefit. A new park going in might be the benefit, and they don't need to do additional work to either mitigate or provide benefits. In other cases, depending on how large of an investment it is, there might be. So one of the things that the bureaus would like to see is some kind of manual similar to the public involvement manual that provides guidance to them. So they've asked that whether the council might support resources to develop that in the coming year. So just wanted to throw that out as another idea that the bureaus have come up with.
Just one last thing, and that's, if we come up with an entire policy that you all really like, but you don't want it in the comprehensive plan, nothing stops you from just having a resolution and then an ordinance to do this in code somewhere else. So it's not a land use decision. So when we get to that point, you can think about that.
Yeah. Good, all right, helpful, thank you very much. We'll move on to historic preservation.
One last item. I know some of you have heard from SEIU with some suggestions for language to 3.3C, which they recommended adding some additional language to recognize different incentives and other tools that could be applied. And I think their recommendations are not inconsistent with kind of the direction that we've been talking about with the Anti-Displacement Coalition, so we'll consider those as well.
So moving to the next agenda item today, it's to look at historic resources policy. So Tom and Brendan will join us here. And like the last topic, we've tried to create some bundles of questions and broad direction. So Tom will start by going over that. It's the one-page document that looks like this in your packet.
Yeah, thanks. Tom Armstrong with the Bureau of Planning and Sustainability, and with me here today is our new Historic Resources planner, Brendan Spencer Hartle, who helped put this together, and actually it responds to some of the testimony that he submitted in his previous position. So this was flagged in testimony, and Mayor, as you said, is an opportunity to sort of look at and up our game on some of the historic resources policies. There's really three pieces to this. The first one, we'll talk a little bit about an issue that's been highlighted about conflicts between the base zoning and the historic district character. And that's really the substantive issue. There's two other issues that were raised around a policy guidance on providing incentives, either financial incentives or regulatory incentives for historic preservations, things like transferring development rights and that sort of thing that was left out of the plan right now that we think should come back in. And the third bundle was just some, I guess, more wordsmithing policies to strengthen and tighten up the historic policies that were in there, and we can highlight some of those. But to get to the substantive issue that was raised in a number of different pieces of testimony, it has to do with the conflicts between what the base zone allows and what it may or be the historic character of the area. And we have some photos and some examples, you know, and this has mainly been highlighted in places like Northwest and Irvington, where the zoning may allow 4, 6, 7-story buildings, but a lot of the historic buildings are in the 2, 3, 4-story category. And so the question becomes, you know, should we make adjustments to the base zoning that more clearly matches that existing historic character, versus sort of what you see here in some of these examples of taller buildings that have that other historic design elements to them, but don't exactly, may not be the same height or scale of some of the other projects. And what we have right now is a recommended policy 4.46, which says it's continuity with established patterns, and the key words in there are preserve and complement historic resources. The testimony that came in has said something to use more like matches existing historic character. And what we've come up with is maybe some interim, somewhere in between, that sort of better takes into account the historic character. And one of the challenges is really defining, well, what is the historic character, and is it more than sort of the style of the buildings, Victorian, Craftsman, or how far does that carry over into the height and scale? Brandon, did you have anything to add in terms of how we frame this issue?
I'll jump in briefly here. Later in the discussion, we'll talk about design guidelines. There, at the moment, is an absence of the phrase design or historic design guidelines in the comp plan. We'll talk about that in a moment. But for the purposes of this discussion, we're really talking about scale, massing, height, what the envelope of allowed buildings are in our historic districts, and whether or not, when we have new historic districts come online, if there's a review of the base zoning to ask, is this really the desired character for scale in that area?
Can I ask, I appreciate the pictures, but I'm a bit confused as to what might be allowed or not allowed under each of these three phrasings.
I'm sorry. There's a continuum in those phrases, and what sometimes occurs now is, as Tom said, you have a base zone that allows a building substantially higher than maybe the historic character of a neighborhood. If when we did a planning process, or if when we adopted the local historic district, that we didn't go back and look at that base zoning. And so we made, an example of that is we made some adjustments in the Elliott neighborhood with our recommended plan to fine tune the base zoning to recognize the historic district that's there. That's an example of taking into account. We modified it, but it doesn't mean that every new building is going to exactly match the height of the one next to it. Match implies a much stronger set of regulations that we may develop to ensure that there is never that situation of a disconnect in height or scale or massing. The complicating factor, of course, is not all districts have a defined scale. There are some that are fairly eclectic and have a variety of scales and styles, but assuming you get past the definition of what the historic character is, then the question is, to what degree does your base zoning and your allowed density take into account?
You regard these as the three points in the spectrum, with preserves and complements being the most permissive and takes into account slightly less permissive, and then matches.
Well, I guess the full spectrum would be ignore on the one end, but
right, ignore it.
we didn't assume that you want us to do that.
So we haven't gotten a lot of historic landmarks cases at City Council in the last few years, but we had one that might be good to remember, and that was in Northwest, where the proposal was to demolish an existing contributing building and build a substantially more massive project. I think it's on Northwest 18th, if I got my street right, in between two rows of lovely Victorian structures. And my sense, the council, I think, was unanimous of that case, and we were affirming, maybe we weren't unanimous. Okay, we weren't, sorry, Steve. But anyway, my sense of that one is that we were looking for development that better took into account the context. We weren't necessarily looking for development that matched. So I don't know, I don't want to extrapolate too much from that case, but again, I think your photographs are helpful, at least in seeing, I know it when I see it, standard of very context sensitive development that does, in some cases, reduce scale in order to achieve higher level of compatibility.
One of the issues that was raised by the Coalition for Historic Resources was the concept of a hierarchy of regulations. So at present, within our historic districts, the Historic Landmarks Commission and Bureau of Development Services do review design proposals for new construction. And in some cases, they run into conflicts as to whether or not an allowed building at maybe 75 feet, like the one the mayor is talking about, could meet the threshold for historic resource review. And having the base zoning, what we do with the base zoning will determine what types of projects go before the commission and before the staff to decide, can we apply our historic resource review criteria to a project of this scale or height or massing that may be allowed by the base zoning, but comes into conflict with the character that's spelled out in design guidelines or the criteria for review.
So Tom, or you guys can kick me if I'm saying this wrong, but I think the direction that we're recommending is acknowledging that we can do more with stronger language than what the recommendation currently is. But we're also not recommending you go quite as far to the match end of the spectrum that some of the testimony suggested.
You know, I think about what it takes into account. It's that the issue was flagged, we grappled with it, and then then we didn't do anything, but we took it into account. I'm afraid that, to me, the term matches suggests that in cities we start creating fossilized districts where we say that there's some historic relic that we're just, in some ways, arbitrarily perpetuating because it came first, which I think is contrary to the spirit of a city that evolves and grows and innovates. But I think complement is actually a word that forces a tougher subjective conversation, because it will be interpreted differently by policymakers and decision makers. But to me, that's what we should be doing, and then defining it in a case-by-case basis about what complementary means, and with the goal of, you know, a livable city and a city that respects its tradition. So I for what it's worth, I think the complement language is an artful compromise.
Another aspect of this that Brandon mentioned was that some of this plays out in the guidelines themselves, and it is that we've noted that there isn't potentially sufficient recognition of the guidelines as a tool in the policies right now. So that was another aspect of our recommendation, was to strengthen reference to those guidelines as a tool to help figure that piece out when we talk about this policy.
I think actually I'm comfortable with either preserves and complements or takes into account, but I agree with Commissioner Fish that we shouldn't adopt a Justice Scalia type policy.
I'll jump in and say right now about 3% of our city's land area is in historic districts, and it's not unreasonable to think that we will have others come online during the life of this plan that may be mid-century modern districts or some of our underrepresented parts of the community. And thinking about those areas where we weren't today taking into account a potential historic district with the base zoning, but tomorrow when that comes up as a potential historic district, how we treat that base zoning is just as important in this conversation as what we have today.
To give you a really concrete example of that, Reedway neighborhood is a fairly coherent mid-century modern neighborhood, and that's one of the reasons for our discussion of the zoning change and comp plan designation change there. But most of the existing buildings are horizontal and one story. But we know that with the R5 base zone, that allows a 35-foot, two-story, and in some cases, narrow house. And so the jarring contrast that many of you see in pictures of is in a lower density context. These examples were all fairly high density, but the same thing can play out and could play out in the future if we were to go down the road of adopting as he said, a mid-century Atomic Ranch historic district.
Let me pose a question to you, and that is, assuming there is interest on the council in strengthening the policy language, I believe we should. It sounds like others agree. Exactly what words we use still to be worked on, and maybe increase the connectivity between the design standards and the plan. Will those changes, in your opinion, increase the pace of neighborhoods seeking historic landmarks designation? Because as Brandon just pointed out, after all these years, we got 3% of the city and districts. It's a big deal to go through that process. property owners incur some costs and difficulties that, have weighed against people forming new districts. So I'm operating on the presumption that there are more places in the city that certainly could qualify to be a historic district, and I think we want to encourage them to go ahead and do it. What do we need to do in the plan to, if that is a goal that we share, what do we need to do in the plan to improve the likelihood of progress there?
I'll jump in quickly. Oregon is the only state in the country that requires owners to consent to historic designation, which means the Bureau of Planning can't decide where our future historic districts are in as thoughtful a manner as other places. So really what we look at is for historic designation, the types of incentives and the types of compelling public interest to create a historic district. And I think what we've seen in current conversations out of Buckman, Eastmoreland, Laurelhurst, is neighborhoods who feel like historic designation is a tool for them to better achieve a desired character, whether that's scale, whether that's protection of buildings that are already there. So with our owner consent law, we do have to be thinking about both carrots and sticks, but it's a little different than most other places.
That another recommendation in here that comes through loud and clear in some of the testimony is to strengthen the language around the need to do more updated inventories, and that's partly why we hired Brandon and why we're moving forward to reinvigorate our historic resources program. And so that's probably the primary thing we can do on our end, given the legal construct that was just mentioned. We can't designate districts until we provide the resources to inventory those resources, and putting that burden on the community makes it harder.
You're saying that in, for example, New York City, the Landmarks Commission and the council and the mayor can impose a historic district without the consent?
That's right. And almost every other major American city has that power.
My guess is, as a practical matter, it's used sparingly. As a practical matter, having lived in New York for a while, I seem to recall that there was a lot of effort to get consent, that it wasn't just imposed without, but you're saying just as a practical matter, legally, consent was not required. Right?
It's a little bit like LIDs. You can, in theory, move forward sometimes, but you often don't.
Okay, so I think what we'll do is try and come back with some policy amendment language that sort of takes us from A to B, and we'll work out that and bring that forward. We sort of touched on, and maybe Brandon can say a little bit more about the next two issues around, providing more incentives and some explicit language like acknowledging historic design guidelines and other inventory explicit, which gets at your question, Mayor, about what can we have in the plan here that supports a more robust historic resources program. And we think with these few changes and tweaks to the language that we already have, that provides that foundation that we need.
Well, in the example the mayor used of that Northwest property, which I guess I do recall, one of the things that I found confusing was the conversation about what was the public benefit that we were looking for. And we got into a discussion, I believe, about how much affordable housing, serving whom. And I think at the time we were struggling a little bit because we didn't have, the sideboards weren't as clear. Are we, in any of these changes, are we providing more clarity about how to have that conversation?
I'm not sure at this, again, comp plan broad policy level, it provides some direction, but what it's really going to take is Brandon and the Historic Resources Program doing more of the design guidelines work, doing more of the inventories that help define what the historic character is and what the key elements we want to see there that will provide those sideboards when making those sort of specific land use decisions in specific locations.
One of the bottlenecks for adoption of additional districts is the fact that, ideally you would have district-specific factors that you consider in the design guidelines. And often what's happened is we've got a generic sort of citywide placeholder to fill in until we do that. And often we have districts, or we could end up in a situation where we have the generic placeholder in effect too long because we haven't had the resources or the investment in doing those district-specific guidelines. And so that's part of this is beefing up the language so that we clearly have the marching orders to go do that work.
I'll jump in and say one other thing. Policy 447 addresses demolition. And since Mayor Cass's administration, the council has had the ability to review demolition proposals for National Register buildings, which is what happened here last December. With that policy and with the current code language for demolition review, this council does have the ability to weigh competing comprehensive plan goals when a demolition is proposed.
One final note at the bottom of the page, we're just noting the recent progress on deconstruction may warrant a little bit more mention in the comp plan, and so I think we're discussing the option of strengthening some of that language as well.
So
I
where,
think, I say one thing about that. Good. I'm glad to hear that, and I hope you were doing this already, but you should not assume that we are done with the topic of deconstruction, having just addressed 100-year-old buildings.
Right.
so where do we address the issue that you shouldn't be entitled, and I know there was a Supreme Court case about this in West Lynn or Lake Oswego, but you can't purchase a house that has an historic register designation and then attempt to remove it?
Good question. So the council passed a resolution in support of a position on a state Supreme Court case that says that once a historic designation is created for a historic property, whether it was 30 years ago or 10 years ago, once that designation has been created, that subsequent owners would not have the ability to remove that designation somewhat arbitrarily. And that case is still pending at the state Supreme Court. I should also mention, we talked briefly about it in the first part of the conversation. We were talking about scale, massing, height. But then in the second part of the conversation here, we've mentioned design guidelines for historic districts. Many of our districts do have historic design guidelines. Some are outdated. And then some of our newer districts have yet to receive design guidelines. So the addition of policy language around having unique historic design guidelines for our unique historic districts could help set those types of sideboards that Commissioner Fish is talking about and give clarity to those districts that have more opportunity for flexibility and a little bit more regimen for those districts that have more of an established pattern.
In passing up here up front, and that is we should also look carefully at the base zoning in the districts that are likely to become historic districts, right? So, Hippocratic Oath applies. In the meantime, while we're waiting for places like Laurelhurst to hopefully complete the process of becoming a historic district, we want to not create perverse incentives for demolition and replacement during the meantime. So we ought to be looking carefully, the council ought to be looking carefully at the base zones in each of those neighborhoods as well. Right?
And the final thought on the strengthening of the existing policy language, there has been quite a bit of discussion about the historic resource inventory, and you're surely be part of that discussion. But with that owner consent law at the state level, we do have quite a few conversations with the city attorney and this commission to decide how we best go out and meet this mandate for inventory. While that's what's going to tell us where future historic districts live, that doesn't give us the regulatory power that it would in, like Commissioner Fish said, New York City or other states.
Yeah, it's that, and it also, it sets us up to have conversations with the local community because they're still able to drive it forward on their terms. And so at least by doing the inventory, we've aided that process.
Questions or guidance for the team on this issue? Good. Thank you very much. Thank you.
The next topic also has a memo attached to it related to employment land. You started to discuss
the employment and economic issues in the first work session we had last month. This is a little bit, that was a broad conversation about the general goal and how you want to frame that. This is a more specific mapping conversation, and we're not intending for you to make to do voting today on this topic, but we wanted to provide a framework for you to talk about some specific mapping choices that you have all started to lay out in your amendment list. And we prepared a memo to help you understand the impact of those changes on our overall ability to comply with State Goal 9 and document our adequate land supply. And so Tom will walk through that memo.
Yes, and so one of the things that will come forward in the amendment package will be an updated EOA that not only reflects the medium cargo forecast scenario that we talked about in the first work session, but that will reflect sort of the direction you give us today on these map changes. And we wanted to highlight and sort of walk through the most significant ones. And then we can sort of, what I think is, the bottom line is that if we make all of these changes that sort of you all have signaled your intent in wanting to consider, we still wind up with a slight, 10 to 16 acre surplus of industrial land. So we meet the Goal 9 requirement with all of these changes. The question then becomes, for each individual case, is that the direction we want to go? And so we had four different ones that we wanted to get some specific feedback from you all and talk about today. The first one has to do with the private golf courses out by the airport, which is the first map on page 2 of your packet. And there we have two different private golf courses. One being the Riverside Golf Club, and then the other one being the Broadmoor Golf Course. The Planning and Sustainability Commission had recommended that we change a portion of the Riverside Golf Club to be comp plan industrial, leave the open space zoning in place that would allow them a future land use change in the future. Riverside has since come in and said, this doesn't really fit our current business model, and we don't like that designation as much as just leave us alone. Meanwhile, sort of between the PSC testimony and coming before you, and in the hearings, we heard from Broadmoor Golf Course wanting to rezone more of their golf course to industrial. And so I think we've heard interest in sort of entertaining both of those options. And what you see is it's not a sort of one-for-one exchange. There's about 60 acres of industrial capacity on the Riverside Golf Club. There's about 20 acres of new capacity on the Broadmoor site. So we wanted to get some feedback from you on which direction we should go with these two pieces.
Now, designating the Riverside property industrial doesn't force the golf course to turn itself into an industrial facility, right? It just leaves open that possibility.
Correct. It just leaves that open. And it's similar to what Colwood was in. It just removes the barrier. Colwood had to go through that comp plan amendment process and then do all their zone changes and development permits. We're just removing one step in the process by saying long-term comp plan industrial, that's okay with us. They would still have to go through a zone change. They would still have to do all of the master planning and the transportation impacts when they wanted to. It's not us saying do it now.
I guess to me, the overriding point is they've been around 100 years. That from all predictions, they're going to be here beyond the next 20 years. And this industrial overlay creates uncertainty for them and for lay people who are thinking about joining a golf club and wondering, is it going to be around or is it going to be converted to industrial property? It hurts their ability to maintain and sustain the membership, which is crucial to them surviving another 100 years. So I support keeping it as it is.
Commissioner, I would argue the reverse, that if they can tell their members that there's a possibility they might convert themselves into industrial, they would say, you better maintain your membership, otherwise we might go away. So I don't really buy that argument. And I have to say that my instinctive reaction is that industrial jobs tend to be reasonably good, well-paying jobs. And I would suspect that from a jobs perspective, you wouldn't want to foreclose the possibility of turning a golf course into an industrial center, not to mention how many walks golf courses spoil.
So I'm a little concerned about discussing these two sites. It seems like we're getting into decision-making on zoning.
Opposed to making decisions on amendments here, so
Yes.
yeah.
The
Reason we want to get some discussion going is we have to prepare an updated EOA that takes into account some of the tentative possibilities. And so we want to, there's a few cases where you all have proposed competing amendments, and we don't want you to make a decision today, but we want you to talk about that enough so that we get the flavor of what we need to do for follow-up, if that makes sense.
Yeah, but your
Close
summary-
votes on these.
Your summary says that we still have enough capacity. It narrows it, so I would be more comfortable waiting to make those decisions. I actually do have a question on the second list of amendments, the dispersed employment areas. Some of them are going from mixed employment to mixed use, and some the other way. But then on some of them, like the first two, the Rossi Farm going from mixed employment to mixed use apparently is minus 4.4, but then Kmart doing the exact same thing is 0. How is that?
It relates to the fact that these are not gross acres. These are acres in the employment analysis. So a particular site, the way we do the math in terms of adequacy of acres is some acres are constrained and discounted because they may have environmental resources, or they may be sloped, or they may have factors there. The reason Kmart is showing as 0 is because it's got development on it right now to the level that it's not actually showing up as a vacant site in our or underutilized. So we may intuitively suspect it's underutilized, but just the cutoff that we established for what counts as formally underutilized, that site is falling slightly above it. It probably is going to create capacity, but the method that we used to document the numbers didn't quite capture it.
Well, let's check in on that for just a moment, and that is, are those criteria of our making, or are those state criteria?
Those are our making.
So, a site that is massively overparked is underutilized, in my opinion, and our criteria should reflect that.
We, the way that it worked in the EOA was that the criteria to determine whether something was underutilized takes into the economics into account of it's inherently conservative because it's looking at what the market is currently doing and what is likely to occur. And so basically on a site like Kmart, what we're saying is the short-term prospect is it's not counting as underutilized land because the economy in that part of East Portland would not likely to produce something much denser at this point in time. We're being admittedly very conservative to be defensible.
So, sort of bouncing off of Commissioner Saltzman's opinion about the golf courses, we need to make a case to ourselves and to the state that we have enough industrial land. So I would go back to that one. If we really don't think that golf course is going to convert during the course of the plan, for whatever reason, then we shouldn't count it, right? If we don't think that's going to happen, or it's very unlikely to happen. On the other hand, we have a lot of underutilized, overparked real estate in the city, particularly in East Portland. I don't, my instincts say the likelihood of actual development on those sites is considerably greater than the likelihood of conversion of golf courses. So our criteria ought to reflect that, in a site, and it's not just the Kmart, but the Kmart site's a class one-story building, cinder block construction, giant parking lot, never even full on Christmas. That's not the only place in Portland that fits that description. Those places seem to me, in many instances, particularly the larger ones, to be great prospects for redevelopment and more employment density. I think we can make that case to our fellow citizens in these kind of lay people's terms, and I think we can make that case to DLCD. So I think we should be. Again, I don't want to play games with the industrial inventory. We ought to be real about this, but I think there's a strong feeling on the council that we can be real about this while still expecting significant redevelopment and densification of employment, because we're already seeing it in places like the Central East Side, and not just there. So I'm concerned that we're being that conservative, Eric.
Yeah, I think we agree. It's just we're trying to establish a methodology that we can defend citywide, and I think we agree that site has some potential, but we also don't necessarily have the data or the economic analysis that would support us being too adventurous with those legal arguments in terms of our supply.
You know, there is a third option here, which is the metaphor would be you make a charitable deduction, but you don't claim it on your tax return.
Yeah.
So there is another option here, which is we look at the golf course. I don't have a strong feeling about the golf courses, but you make the change that's recommended, but you don't count it towards your total. So you're saying we want to be flexible, and at some point the golf courses may decide they want to go that route, so we want to do that now. But we're not claiming the credit for something that we know is not going to happen.
Yeah, and that's essentially our strategy. If we were to maintain the employment designation on the Kmart site, that's essentially what we're saying, is that we think there's a reason to do it, but we're just not claiming credit for it.
On the Kmart side, it's really the flavor of the jobs going from retail to, the light industrial middle wage jobs. And in the end, when you get down to the bottom and we've got to find room for 140,000 new jobs, a job's a job. And that's why in the EOA showing up as capacity, it's going from retail jobs to industrial jobs, light industrial jobs. And that's why it doesn't show up.
Looking at recent trends, looking at the growth of the distillery industry in the city, that has been refilling some of the spaces in the Central East Side. That's to me an example of the kind of intensification of employment in craft, in areas where we've got lots of places in the city, 99th and Burnside, a lot of the 82nd corridor, the stuff along 17th, some of which is already mentioned here. There are a lot of places where we can create the environment where that kind of relatively small footprint, relatively high employment density place where people make stuff, employment can happen. And the Kmart site may be one of those. So to me, it doesn't seem like a stretch if you look at what is going on in land prices and redevelopment for that kind of employment. It doesn't seem to me a stretch that we get more aggressive about counting. One, it's not just a debate with DLCD, it's also that we're trying to accommodate the kinds of employment growth that we want to see, and those are certainly, makerspace is one of them.
Well, I think what we intended to do here was to stimulate some of the discussion we just had, and to point out, when you do get to making decisions on this, there are a couple key sites that are in this list that you all have potentially competing amendments that we want to make sure that there's that fact base behind the decision making. And so we're available and continue to be available over the coming weeks as we get into the hearing to discuss those. The golf course is one area where you've potentially got slightly different takes on it. The Kmart is another one where you've got some potentially competing directions out there. So we want to, and some of them we just don't know where you are because we haven't talked to all of you about it. So which is fine at this stage. There are a few in this list, Pepsi and Adidas being examples where, as we've gotten into the mixed use zoning and refined that, we have started to realize that there's a couple of those sites that would make more sense as employment, and so that stimulated our recommendations to the mayor that those be added to the list. And that's a reflection of, if you recall the history of our mixed-use zones, the EX zone started out as an employment zone, and through a variety of refinements over the years, it turned into the Pearl District zone, which is primarily about housing now. But there are some legacy employment sites that still have EX and aren't intending to change to housing anytime soon. And so as we shift over to the new mixed-use framework of the new zones, some of those sites are more appropriately returned to the employment designation, I think, because they have no immediate or longer-term even interests in converting. And so some of those are, Adidas in particular struck us as there's no reason we need to encourage change there other than to continued investment in the jobs. So that just reflects refinement of the map as we've learned more in the mixed-use work.
Just to tag on that last point. So the Adidas campus, I mean, what if they wanted to provide housing at some point for people who work there? Would they not be allowed to under the mixed employment zone?
Correct. But I mean, we've had discussions with Adidas and their facility manager and trying to figure out what the best fit is. And based on those discussions, we think the mixed employment is the better designation for what they want. And we can provide more insight into those discussions and how we arrived at that.
Yeah, I mean, I just picked that last example,
Yeah.
but there's several other examples you flagged for us where I guess I would ask that same question. I mean,
In most
do
of
we want
those,
to rule out housing?
in most of
altogether?
those cases, there's an adequate supply of mixed-use zoning across the street and next door, so that we're not too worried about the possibility of housing serving that employer.
So when are we going to talk about the medium forecast and the language on West Hayden Island? Is that at another work session?
At this point, the language we've circulated,
I think some initial draft language to folks on the EOA and how we describe its relationship to West Hayden Island. So at this point, we were not planning on having another work session on that. That's just a matter of voting on the language and having one-on-one conversations about that.
Okay, and then an email that I have says that the comprehensive plan calls for frequent reevaluation of demand. The EOA updates every 5 to 7 years. Is that required by the state?
Not necessarily, but we're proposing that because our land supply is tight and because we think that benefits us over the long run. If you look backwards in time and use the residential analogy, it used to be much harder for us to document residential infill, and so we had a really conservative buildable lands inventory on the residential side all the way up through the 90s and into the 2000s. And we're now able to claim more credit on those underutilized lands because we have a history of denser infill. So moving forward, we think a regular update is to our advantage because we're seeing more and more of these multi-story employment uses, and we're going to be able to document more of that, which helps our land supply rather than harms it.
So I'll want to have some more conversations with you on that. I think no future council member wants to continue doing this every 5 years. It seems like
Feels so good.
Prometheus pushing the rock up the hill.
so the
Last item on today's agenda was just to remind you of next steps and do a little Q&A if necessary on how that's going to work. On the back of your agenda, there's a list of the key dates, which I think Joe mentioned at the beginning. Sometime in the next few weeks, we're intending to publish a document that has the actual maps of the sites that you all have nominated for potential change, and also has language on the policies that you've discussed with us. That will be the basis of a hearing on the 14th and the 20th. It doesn't mean you can't amend your amendment after that, but we wanted to establish a stable point to which to base the hearing on. So that's our next step.
And I was going to suggest that we might want to set a date for when we propose amendments to amendments?
Yeah, so April 28th was the tentative date for where we actually bundle up the amendments and go through the voting on those different bundles, some of which will be non-controversial consent lists, and others might be individual votes because you all might have different points to make. And then May 25th and the 15th are the dates where we actually try and wrap this up in terms of adoption of findings and the final voting of the as amended plan. But the mayor, I think, wanted to make a few points about how we handle the, after we've heard testimony on your initial collection of amendments, then what do we do?
Right, well, I think we want to make sure we're transparent about that, and we don't agree, and we will have split votes on some of these issues. That's fine, that's good. So I was going to suggest that we ought to set a date somewhere between the 20th and the 28th, maybe the 22nd, where we say, if you've got an amendment to the amendments, put it on the table, so we can the rest of us can evaluate it, and so we can get it out there in public discussion.
Mayor, I really applaud that, and I hope we consider that a directive, because having participated in some really great processes on this council where we've had literally dozens and dozens of amendments, and staff has done a great job framing them, and we've tried to debate them, and the public's tried to follow along. It just seems to me that we're now at a point where if we don't follow that guidance, everyone's going to be confused on Judgment Day.
Right.
And so by putting out amendments to amendments a number of days before, your colleagues come in better prepared, the public can follow what's going on, and I hope we're faithful to that, because I think it would be a great refinement of our policy.
Anyone have a concern about that approach?
No, actually, you have a concern about something else, though, which I just realized. I'm going to be out of the country on May 25th.
Well, we can figure out how to divide that. So, hearing no dissent, I am going to set April 22nd as the.
What day of the week is that?
Good question.
Saturday?
And while you're looking it up, I'm thinking about canceling all leave for everybody in my office for the 2 weeks between the 14th and the 28th.
Friday, April 22nd, as the date. At 5 p.m. Friday on April 22nd, we should put our amendments to the amendments on the table.
A question on that, is anybody going to be looking at them over the weekend, or could we make it 8 o'clock on Monday?
Sure, we
Morning.
can make it, that makes it the 24th, 25th. So then, that's 3 days before the hearing.
Well, the hearing is the 14th and the 20th. And
Okay,
then
all right,
The
sure.
vote is
28th.
3 days before the votes.
It's amendments to amendments, so I think that's manageable.
It really is a question as to whether others are going to be working on it over the weekend, or whether those who might need more than 2 days between.
Yeah, no, I'm sensitive to that, yeah.
Well, I'm also not going to go on vacation those 3 days. so.
I don't think anyone is. All right, Monday morning, 9 a.m. Monday morning on the 25th.
Mayor, there's one other important piece of business we have to do, but I'm reminded that we're not allowed to make any decisions, but I have been keeping track at attendance at these comp plan hearings, the public hearings, the work sessions, and the coveted Netta Coven Award, which will go to the person with the best attendance record. I believe the Rossies may be firmly in the lead. I notice there's some lawyers who've been joining us regularly. They have some catching up to do. But we can't make any decision today, but I think they are probably the prohibitive front runner.
But let's go back to Steve's question also about you're going to be gone on the 25th of May. And what we're doing then is vote first, findings second, right? So-
Votes on the amendments to establish what the as amended plan is, and the reason we have a month of waiting.
That's on 20.
First reading.
Yeah, it's actually the findings first, and then the final vote second.
Oh, all right, so you'll be missing the vote on the findings.
Is that okay?
Probably.
Yeah, I think that's probably not
Practically,
working.
if we're split 2-2, which I don't think is going to happen, the mayor's probably going to set that over a weekend.
Right. Yeah, that's probably not going to happen, exactly. I wouldn't expect that.
Just as a side issue, just for mythological accuracy, Commissioner Fritz, So it was, yeah, so Sisyphus was the guy pushing the rock up the hill, and it was Prometheus was chained to a rock and having his liver eaten daily, which I don't think even the worst comp plan proceeding compares to.
Yeah, but you had to look that up, right? So
That's like going.
I was
to-
hoping that nobody would notice, because as soon as I said, I knew Sisyphus.
I wanted to, I had to look up the liver part to make sure I had that right.
Are there any other questions about process?
On that note, let's hope the comp plan process never feels like that.
And I just want to remind you, because it's my goal to get this report out in the next week or two, this is the important week for you all to be reconciling language suggestions with BPS staff so that we're clear on what your amendments actually are. We're pretty good about that. I know there's a few other meetings this week, but I just want to emphasize that point.
Great, well, another good discussion. Hope these work sessions have been helpful for all of you. It have been for me, and I just want to thank the BPS staff and their support team and other bureaus for really getting the council to a level of understanding here of the decisions in front of us, so thank you.
And Mayor, I also want to say they're going above and beyond. The staff scheduled a boot camp with me last week, and we did a couple hours of a deep dive in my office, and my staff and I really appreciated that chance to do a focused tutorial on some of the endgame issues, so thanks for your good work.
Thank you all very much.